If you own a home, if you are getting older, if you have any savings at all, there is one part of the long-term care system I do not want you to misunderstand, because people misunderstand it every day. And the misunderstanding is expensive enough to erase a lifetime of good intentions. It is usually described with a deceptively harmless phrase, the 5-year rule. That phrase sounds technical, almost academic, like the sort of thing a lawyer would mention in passing while flipping pages. It is not academic. It is one of the clearest examples in American finance of how a family can do what felt loving, ordinary, and completely legal, and still end up trapped between a nursing home bill they cannot pay and a Medicaid system that refuses to step in when they thought it would. That is the real danger. Not that the rule is hidden in some classified vault, that people hear about it too late, or hear the wrong version of it, or assume it cannot possibly apply to them because the gifts were small, informal, and made in good faith. So let me slow this down and explain the machine. In most states, when someone applies for long-term care Medicaid, the state reviews asset transfers made in the prior 60 months. That is the look-back period. Federal law has used that 60-month framework for years. California's MEDI. Cal is now a major exception for nursing home entrance from the 1st of January 2026 forward. The state says it will look at transfers made in the prior 30 months instead. That difference matters, but it does not make the larger issue go away. The larger issue is that Medicaid is not merely checking what you own now, it is checking what you gave away before you applied. That is the part people miss. They think eligibility is about what is left. Very often, it is also about what left before. And once the state decides you transferred assets for less than fair market value during the look-back window, it can impose a penalty period. That penalty does not mean a fine in the ordinary sense. It means Medicaid will delay paying for the long-term care services you are applying for, so you can end up in the most destructive of all financial positions, too poor to pay privately, but penalized so Medicaid refuses to pay yet. That is the trap. The family thinks, we already spent down, we already need help. So surely help starts now. The state says, number, you should not have given that away. The nursing home says, we still expect to be paid. That is how ordinary people get crushed. Now let me say something clearly, because this is where many families make their first fatal assumption. The look-back rule does not only catch huge transfers, it can catch small, normal family-type money, movements that never felt like planning in the first place. A check to a grandchild paying part of a child's tuition, helping with a car, forgiving an old family loan, selling something for far below fair value because they are family. A gift that is perfectly acceptable under IRS gift. Tax rules can still create a Medicaid transfer penalty. That distinction matters more than almost anything else here. The IRS has one set of rules, Medicaid has another, and people confuse them constantly. They hear that the federal annual gift tax exclusion exists and think that must mean the gift is safe. Safe for gift tax reporting is not the same thing as safe for Medicaid eligibility. Those are different systems with different goals. One cares about tax administration. The other cares about whether you transferred resources away before asking the state to pay for expensive long-term care. If you remember that one distinction, you will already understand more than most families do when the crisis begins. Now let us talk about cost, because this is the part that makes the whole structure so vicious. Long-term nursing home care is not cheap. CareScout S2025 national median for a private room is $129,575 a year. And even a semi-private room runs $114,975. So when a penalty period is imposed, the bill that lands in front of the family is not some manageable little bridge loan. It is a 5-figure monthly problem, and that is why penalty periods are so destructive. The family usually already applied because they could not comfortably self-fund any longer. So when Medicaid delays coverage for months, the question becomes very ugly very quickly: who pays during the gap? That is why late planning feels so cruel. You can see the cliff, but you are already sliding. Now, I also want to say something about spouses, because this is where many families tell themselves another comforting story. They say, well, at least the healthy spouse is protected. There is protection. But protection is not the same thing as abundance. Medicaid has spousal impoverishment rules, and in 2026, the maximum community spouse resource allowance is $162,660. There are also income protections through the monthly maintenance needs allowance. So yes, the at-home spouse is not supposed to be left with absolutely nothing, but do not romanticize that. What sounds like a large number in conversation can feel very small when you realize it may need to support property taxes, insurance, food, repairs, premiums, emergencies, transportation, and all the ordinary chaos of living for years. This is one reason I hate slogans in planning. People say the spouse is protected, as though that ends the analysis. It does not. Protected is not the same thing as comfortable. Protected is not the same thing as future. Protected is not the same thing as you can stop planning. Now let us talk about the house, because this is the part families care about most. They want to know whether the house is safe. The honest answer is more complicated than most people want. While the applicant is alive, the home is often treated favorably for eligibility purposes if the person intends to return home or if certain protected people live there, such as a spouse. But that does not mean the house is untouchable forever. Federal Medicaid law requires states to pursue estate recovery for certain Medicaid benefits paid on behalf of people aged 55 or older. And estate recovery often centers on the home because the home is frequently the largest visible asset left in the estate. Now here is the important boundary. States cannot recover while there is a surviving spouse or a surviving child under 21, or a blind or disabled child of any age that is federal law. So again, I want precision here. This is not the state instantly takes every house the moment Medicaid is used. That is too sloppy. The more accurate statement is this: if long-term care Medicaid paid large amounts on behalf of a beneficiary who is 55 or older, the state is generally required to seek recovery from the estate later, and the home is often the asset families care about most when that recovery claim finally appears. That is the real pain. Families spend years assuming the house is somehow sacred because nobody forced a sale during the applicant's life. Then death occurs, probate begins, and the estate recovery letter arrives like a second funeral. That is when people realize the difference between exempt for eligibility and protected from later recovery. Those are not the same thing, and if you do not understand that difference early, you are likely to understand it at exactly the worst moment. Now, the uploaded document also raises another emotionally loaded issue: filial responsibility laws. Here again, I want to be careful because this is one of those topics people love to sensationalize. Yes, some states still have filial responsibility statutes on the books. And yes, there have been cases where adult children were pursued for care bills. But the real world is messy, state-specific, and much less uniform than the headline version suggests. So I am not going to build the whole warning around that. I do not need to. The estate recovery and transfer penalty framework is already serious enough. Now let us come to the document that actually matters. If you want to avoid turning your home and savings into future nursing, home collateral, the most important long-range planning tool in this whole conversation, is not a simple will. It is not a basic revocable living trust. It is not a general power of attorney by itself. The key document families usually need to at least discuss is a Medicaid asset protection trust. Notice the wording "discuss." I am not saying every family automatically needs one in the exact same form. State law varies. Family goals vary. Some situations call for other structures. But if you or your parents are trying to protect a home and other countable assets from the combined pressure of the look-back rules and later estate recovery, this is the phrase you need to bring into the room. Not do I need a basic estate plan, not can you do a will, not can you make sure everything goes to the kids. Number, you asked specifically about Medicaid planning and whether a Medicaid asset protection trust makes sense in your situation. Why? Because a basic estate plan is mostly about what happens when you die. A Medicaid asset protection trust is about what happens if you stay alive long enough to need expensive care first. That is the difference, and it is one of the most expensive differences a family can ignore. Now, a Medicaid asset protection trust is not magic. It is usually irrevocable that matters. You do not get to keep the same casual control over principal that you would have had in your own name. The structure works precisely because the assets are no longer simply sitting there under your direct personal ownership in the same way, properly done and properly timed. That changes how they are treated after the look back period is run, and timing is everything. This is the point I want burned into your memory. The clock does not start when you intend to plan. The clock does not start when you read an article. The clock does not start when you finally admit you should probably call someone. The clock starts when the planning is actually implemented and the assets are actually transferred into the structure. That is why delay is so expensive. Every month you wait is another month added to the back end of your risk. Now, in a few states, there is also another tool people need to know by name: the Lady Bird deed, also called an enhanced life estate deed. This is not a substitute for full Medicaid planning, and it does not solve every asset problem. But in states that recognize it, It can be powerful for the house specifically because it may help the property pass outside probate and therefore outside the estate recovery path that many families otherwise walk straight into. Texas law libraries and legal aid resources recognize it, and so do many elder law practitioners in Florida, Michigan, Vermont, and West Virginia. But again, this is state specific. Not all states recognize Lady Bird deeds, and not all fact patterns are suited to them. That is why I do not want you grabbing random forms off the internet and feeling proud. This is not a do-it-yourself weekend project if the house matters. This is one of those areas where using the wrong tool with great confidence can hurt you more than doing nothing for another week while you find the right lawyer. Now let me tell you what I think families should actually do this week if this issue is even remotely relevant. First, pull the records. Not eventually, now. If a parent is older, owns a home, and there has been gifting to children or grandchildren, you need to know what actually happened in the last 60 months. Not what you vaguely remember, not what everyone assumes. Actual statements, actual transfers, actual dates. Make a list. Second, stop assuming the family's current estate attorney necessarily handles Medicaid crisis and pre-crisis planning at a high level. Some do, many do not. There is a reason the certified elder law attorney designation exists. Third, when you talk to counsel, do not ask only for a will or a trust. Ask directly about Medicaid planning. Ask directly about transfer, penalty exposure. Ask directly about estate recovery. Ask directly about whether a Medicaid asset protection trust or estate specific deed strategy should be considered. Fourth, if you live in a state that recognizes Lady Bird deeds and the house is the main asset, ask about that specifically by name. Do not assume the lawyer will raise it without prompting. Fifth, do not comfort yourself with the phrase, "we still have time," unless a qualified elder law attorney who has seen the entire fact pattern says you still have time, because maybe you do, and maybe you do not. That is the whole problem with this area. Families often think the danger begins when someone enters a nursing home. Very often, the real danger began years earlier when they were still casually gifting, casually moving assets, casually using documents designed for death instead of documents designed for long-term care risk. That is why the 5-year rule feels so cruel. It punishes ignorance retroactively, and the only real antidote is earlier planning. So if you want the plainest version of everything I just said, here it is. The 5-year rule is dangerous because it is not really about 5 years. It is about whether you acted while you still had the luxury of time. Once the care need is here, your options narrow, your leverage collapses, and every month of delay becomes more expensive than the one before it. That is the real lesson. Not panic, not fatalism. Timing, if you want to protect the house, protect the savings, and avoid turning love gifts into Medicaid penalties later, the most valuable move is usually the least dramatic one. Start earlier than feels necessary, because in this part of life, earlier is what eventually feels like on time.